Have you ever wondered what would happen if a legal case was basically over the second it started? Well, we're about to dive into a real-world dispute between a property owner and their HOA, where, believe it or not, a single word in a hearing decided absolutely everything. It's a fascinating look at how simple rules can lead to some surprisingly clear-cut outcomes.
So picture this. It's August 17th, 2022. You're in an administrative hearing, and the judge just lays the entire case out in one single sentence. It all comes down to one question. Was the Homeowners Association following its own rules on June 6th, the day the complaint was officially filed? That's it. That's the whole case.
So what was the HOA's big, elaborate defense? They didn't have one. No argument, no justification, just one word. Yes, that's what they said. With that one little admission, the whole thing was settled. The violation wasn't even up for debate anymore.
Right. I mean, with the violation admitted right out of the gate, this hearing was never going to be about if a rule was broken. Everybody in the room agreed it was. The only thing left to figure out was, so what happens next?
You know, that one-word answer just completely changed the entire dynamic of the hearing. There was no need to argue over evidence or bring in a bunch of witnesses to prove something everyone already agreed on. It basically turned what could have been a long, complicated legal battle into a simple matter of procedure and really accountability.
Okay, so how did we even get to this point? To really understand what happened, we need to rewind a little bit. Let's meet the key players and take a look at the specific rule this whole case was built on.
All right, so on one side, you've got M&T Properties LLC. They're the petitioner, the property owner who spotted a problem, filed a formal complaint, and put down a $500 filing fee to get it heard. And on the other side, that's the Kivas Uno Homeowners Association, the respondent. They're the ones who had to answer for their actions, or in this situation, their lack of action.
Now, this entire case hinges on a document called the CC&Rs. And hey, if you live in an HOA, you've got one of these too. And you need to know these things aren't just suggestions. They are legally binding contracts that every single homeowner agrees to follow when they buy their home. It's basically the constitution for the neighborhood.
And here it is. This is the exact rule at the heart of everything. Take a look at the wording here in section 6.7. It doesn't say the board may or should consider hiring a manager. It says they shall. Now, in legal speak, shall is not a suggestion. It's a command. That one word makes the requirement completely non-negotiable.
So, you've got a mandatory rule and an admitted violation. Suddenly, the path to a final judgment becomes incredibly clear. Let's just walk through how it all played out.
The timeline itself is about as straightforward as it gets. The petition pointing out the violation was filed on June 6th. The hearing, the one where they immediately admitted fault, that happened just over 2 months later on August 17th. And the judge's final written decision, that came down less than a month after that on September 6th. Pretty quick, all things considered.
So what was the HOA's big excuse? Well, according to the judge's official findings, the board's director basically said they just didn't know about the rule. And honestly, that's a classic problem for volunteer boards, right? You've got well-meaning neighbors trying to serve their community, but they might not be experts in legal documents or the fine print of their own rules.
Now, to be fair, the HOA did eventually scramble to fix the problem after the complaint was filed. But the judge had to point out a really critical legal principle. Fixing the issue later doesn't erase the fact that you broke the rule in the first place. The only thing that mattered was what was happening on June 6th, the day the petition was filed. Period.
So the violation was admitted, the we didn't know defense didn't work. What were the actual consequences? Let's break down the judge's final order.
First thing, there was a direct hit to the wallet. Since the property owner was proven right, the judge ordered the HOA to pay them back for the $500 filing fee. It makes sense, right? The cost of taking legal action fell on the party that broke the rules to begin with.
The judge's final order was just a really clean 3-part resolution. First, the petition was affirmed, which is the official way of saying M&T Properties won. Second, that filing fee had to be repaid. And third, the HOA was formally ordered to follow its own rule, Section 6.7, from now on, ensuring they'd actually comply in the future.
So, what's the big takeaway from this whole open and shut case? Well, it's a huge reminder that those CC&Rs aren't just suggestions. They are legally enforceable contracts. It also proves that ignorance isn't a defense, especially when you're a board member with the duty to your community. And maybe most importantly, it shows that there is a formal, accessible way for homeowners to hold their associations accountable.
This entire case came down to one sentence in a document the board admitted they hadn't read. It really makes you think, doesn't it? What's hiding in plain sight in your community's rulebook? Are you or is your board just kind of governing on autopilot? This case shows that not knowing the rules isn't an excuse, it's a liability.